Johnson.
Alexander, on behalf of the people, Your Honor.
We have the amendment.
Alex Warren, Green on behalf of Mr. Johnson.
Oh, that's after the call. Okay. All right.
What? With the testimony of a police officer. Just this. Your Honor, today's date and time for preliminary examination. The prosecution just informed me that they are able to proceed and that they were seeking to proceed under the exception laid out in 768.27C. Relayed that to my client. I do believe my client wishes to waive his right to a preliminary examination today. I was just relayed this information, Your Honor. If the court could accommodate passing this matter, I can better inform my client of what that means.
That's correct, Your Honor. We would be looking to proceed under 27C.
All right. I'll pass it and let you go back and talk to your client.
Thank you, Your Honor.
All right. So what?
Complaint.
Yep. I'm
They'll bring him out if you're
Is
ready.
Yeah, I'm ready. Court calls the case of the people of the state of Michigan versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Johnson. Your Honor, today's the date and time for preliminary examination. I appreciate the court's accommodation in passing this matter earlier. I did have an opportunity to speak with my client. My client does wish to proceed with examination, knowing that the people do intend to proceed using the exception laid out in MCL 768.27C. And I think he understands that by proceeding, the people would be rescinding their offer of not adding any habitual offender sentencing in exchange for his waiver.
Okay. And sir, that is your decision?
Stand up.
That's your decision?
Yeah, my attorney said that,
Well, I don't want to know what your discussion.
witness. Or,
Mr. Johnson, when we spoke, I explained to you that there is an exception to.
At this moment, the judge slows everything down for a reason. Johnson appears confused about what he is agreeing to, especially with the possibility of habitual offender consequences. The judge wants to make sure this decision is informed, not rushed, and that pause could become very important.
The general rule laid out in MCL 768.27C, under which the prosecutor could make a showing and the prosecutor could have a preliminary examination without the presence of the person who directly accused you of this. You understand that, right? Yeah. Okay. So you understand that if we proceed right now, we are going to have a preliminary examination, right?
but you said in the back, if she
Well-
wasn't here, that I would be let go.
Okay, hold on. Because I really don't want your conversations on the record. Why don't I take a break, let you discuss with him in more detail in terms of what he wants to do. So why don't I give you about another 15, 20 minutes and you guys can figure it out. Because I want to make sure he understands what he's doing, particularly since there may be habitual offender charges that could be filed.
Thank you, Your Honor. I really appreciate the court's accommodation.
Or stand in recess.
All right.
Judge call the case of the people versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Johnson. Mr. Johnson, can you state your name?
Sean Johnson.
All right. And are we going to have a examination? Going?
The people are ready to proceed.
And Your Honor, I did have an opportunity to speak with Mr. Johnson at length. I think Mr. Johnson understands people's position. At this time, he does wish to waive his right to a preliminary examination. The people in exchange have agreed not to add any habitual offender sentencing enhancements. Could you sign?
All right. Mr. Johnson, is that correct?
Yes,
I'm sorry, are you, I think you said yes, but your handcuffs hit the,
yes.
all right. And Mr. Johnson, you understand,
Now the decision is official. Johnson waives his preliminary examination, meaning the case moves forward to circuit court without that probable cause hearing. But the judge isn't done. There's another issue waiting involving his jail phone privileges, and that's where the tension starts building again.
finish signing there. You understand that a preliminary examination is a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it. You understand that, sir? Yes?
Yes.
All right. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution of this case. You understand that?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, court will enter a not guilty plea. Pre-trial in this matter will be set for
June 26th at 1:30 PM with Judge Slade.
June 26, 2025, 1:30 before Judge Slay.
And Your Honor.
Is there anything sooner than that? Please.
Hold on. Because that's, you may be right, because that sounds like an exam hell date.
I'm just giving you some willy-nilly, how you like May 22nd.
We'll get you a quicker day, May 22nd.
Okay.
Thank you, Your Honor.
May 22nd, 2025, 1:30 before Judge.
I just want to talk to my daughter, Your Honor.
And Your Honor,
Yes.
I did want to bring to the court's attention, after the defendant's phone privileges were revoked last time, he did try to attempt to make a call with the same number to the victim, but the victim's number was blocked from the jail. I am concerned that he tried to call that number again.
Um,
I don't want to punish
Hold
my
on,
daughter.
hold on,
Your Honor.
Mr.
all right,
Johnson.
Johnson, let me just say this. I revoked your phone privileges because I felt that I had to. You would have been entitled to a hearing and the like. But sometimes, sir, what you got to do is you got to let the process work itself through. And if you keep trying to force things and do things, it's just going to cause you more headache and more problem. I'm not going to take any action on what the people are raising, okay? But I'm going to suggest as this case proceeds toward Judge Slade, that you not enter into that behavior.
I just want to talk to my daughter.
I know, but you'll get there, you'll get in a position to do that sooner if you follow the rules that we have now, okay? Bound with its conditions will continue. Thank you.
Thank you, Your Honor.
What is the bond anyway?
It's $15,000 cash. And we can pass that in Judge Slade's court on the 22nd, right?
Thank you.
Thank you, Your Honor.
I'm sorry I took too much time.
No, you didn't, sir.